Mr. Haoucher immigrated to Australia from Lebanon in 1977. His 5 brothers and sisters came around the same time. It would seem that Mr. Haoucher had some difficulty complying with Australian laws. In the early 1980s, he was convicted twice for assault, and then in 1985 he was imprisoned for supplying cannabis resin. After the assaults, he had been warned by the Immigration Department that any further convictions could result in him being deported back to Lebanon. About 2 months from the end of his prison sentence, the department issued him with a deportation notice. He challenged the notice in the Administrative Appeals Tribunal, and the tribunal recommended that the deportation order be overturned. Now, under many types of legislation, that'd be the end of it. But in immigration law, the minister retains a final discretion in cases such as this. So the minister had the power to ignore the AAT and deport Mr. Haoucher anyway. The minister at this time was Mick Young, who had made a statement in Parliament where he said this: "It is the policy of the Australian government that recommendations of the Administrative Appeals Tribunal should be overturned by the minister only in exceptional circumstances and only when strong evidence can be produced to justify his decision." In Haoucher's case, however, Minister Young decided to overturn the AAT's decision. Haoucher appealed on the basis that the minister's statement in Parliament had given him legitimate reasons to expect that the AAT decision, which had gone in his favour, would only be overturned in exceptional circumstances, and that he should have had, as a matter of natural justice, an opportunity to be heard on whether such exceptional circumstances existed. The dispute split the High Court, and there's a number of written judgments, but the judgment of Justice Toohey is probably the leading one. He said, if, as here, the minister asserts that the reconsideration was in accordance with the criminal deportation policy, the deportee is entitled to know what were the circumstances said to be exceptional, and what was the evidence said to be strong, and to be heard in answer. Procedural fairness requires that much. This case teaches us that while government policy does not have the authority of legislation, the public expression of a government policy can, in some circumstances, give rise to the legitimate expectation that the announced policy will be followed.